In which one of the following cases the Supreme Court was in 2017 declared pronouncement of the talaq three times at a time by Muslim husband is unconstitutional? Answer: Saida Banu versus Union of India. Which one of the following is not a main source of Muslim law? Justice, equity, and good conscience are secondary source of Muslim law. Sunnah, Ijma, and custom are primary source. The term urf under Muslim law means custom. Primary source of Muslim law in which supplement its. Which one of the following is an essential condition for marjal maut? Answer: there must be an apprehension to death. In which one of the following is not a school of Muslim law? Answer: Zadia is not a school of Muslim law. Hanfi, Malkai, Hanbali is school of Muslim law. Which one of the following is not an essential for valid gift or hibba under Muslim law, Mohammedan law? D. Written documentary proof of the gift is not necessary. Declaration of gift, acceptance of gift, delivery of possession of the gift by the donor to the donee. These three are essential conditions. Who under Muslim law can claim right of pre-injunction? All of them can claim right of pre-injunction. Safi-e-Sharik, a co-sharer in the property. Safi-e-Khalid, a participator in immunities and appendages. Salfi-el-Jar, a owner of contingent immovable property. Hibba of future property in Muslim law is. Answer: void. Under Muslim law, a will may be made of. Answer: one third of the property. B. Under Muslim law, if the donee die before acceptance of gift, then the gift is. Answer: A. void. After divorce, a Muslim woman can validly remarry after observing the iddat period. Which one of the following is not a school of Sunni law? Muttazila is not a school of Sunni law. Hanbali, Malkai, or Shafi'i is a school of Sunni law. Muslim laws of marriage. When in Muslim marriage meher is unspecified, the wife is entitled to get mahar-e-misl. A marriage prohibited under Mohammedan law by reason of difference of religion is done is. Answer is irregular. A Muslim is prohibited to have two wives at a time if these two wives related to each other by. Answer: all of the above. Consanguinity, affinity, fosterage. In Muslim law, when husband and wife both desire separation, the transaction is known as mubarat, divorce by mutual consent. The provision of Dissolution of Muslim Marriage Act 1939 gave right of judicial divorce to. Answer: wife only. Dower is all of the above. A mark in respect to the wife, a consideration to the marriage, an essential incidence of the marriage. 19. According to Shia law, to execute the marriage in presence of witness is not necessary. In Sunni law, two witnesses are necessary. One in which one is male necessary. Which type of Muslim marriage is performed temporarily for enjoyment? Answer: Mutta marriage. A marriage of Muslim with a woman prohibited by reason of affinity shall be void. Under Section 2 of Dissolution of Muslim Marriage Act 1939, the ground of the divorce are available to wife Answer is A, C and D. Where whereabouts of husband has not been known for a period of 4 years. This one is ground. For 4-year imprisonment of the husband, this one is not a ground. Husband has treated her with cruelty, this one is ground. Husband has neglected her or failed to pay her maintenance for a period of 2 years. Give the correct answer with the help of code given below. Mutta marriage is a temporary marriage, right? Recognized under Sunni law, wrongs in recognized under Shia law. Recognized under Shia law, a marriage for a fixed period. With whom Shia Muslim may entitled to perform temporary marriage, that is Mutta. Any one or any of the women stated above, that is Muslim women, Christian women, Jew or fire worship women, anyone, not idol worshipped women. Which one of the following is not an essential for valid marriage under Muslim law? Fosterage is not an essential. Offer and acceptance, competency of party, pre-consent is essential. Iddat is a period during which Muslim women is prohibited from marrying on dissolution of marriage. By death or divorce. Both A and B are right answer. Under Muslim law, a married woman shall be entitled to obtain decree for dissolution of marriage on the ground that whereabouts of husband has not been known for a period of 4 years, as provided under Dissolution of Muslim Marriage Act 1939. Section 2I, whereabouts regarding Section 2I, I1, Section 2, Subclause 1. Under the Dissolution of Muslim Marriage Act 1939, a Muslim wife can seek dissolution of marriage if husband failed to perform a marital obligation for 3 years. Sunni Muslim consider Mutta marriage as Sunni. In Sunni it is void, in Shia it is valid. Sunni marriage without witness is Sunni. In Sunni, marriage without witness is irregular. If there is a stipulation on part of the women before marriage to forego all her right to the dower, or even if she agreed to marry without any dower, the stipulation or agreement will be invalid. Dower is an essential condition of marriage in Muslim law. If Sunni Muslim marry with Kitabiya girl, the marriage is Irregular. A Muslim marriage contracted without witness is irregular. In Sunni school, 2 witnesses are required. In Shia, no witnesses are required. Tuhar means the period between 2 menstrual cycles. Dissolution of Muslim Marriage Act 1939 is based on the following school of Muslim law. Hanfi school. In which one of the following cases the Supreme Court held that we are not prepared to express any definite opinion on the question whether there can be 2 karta in the joint family. This one is related to Hindu law. Union of India versus Sri Ram Rohad. Dissolution of Muslim Marriage Act 1939. About a various round of dissolution of marriage based on principle of D. Malkai School. Which one of the following enactment provided for dissolution of marriage only at the instant of wife? Dissolution of Muslim Marriage Act 1939 gave a special enactment for the dissolution of Muslim marriage on the instant of wife. Muslim marriage take place without fixation of dower. Marriage will be Sahi. A Sunni Muslim husband marry his wife's sister. The marriage is irregular. Marriage of a Muslim male to his maternal uncle daughter is maternal uncle daughter मामा की बेटी मौसेरी बहन is valid. Children of 2 sisters can validly marry under which one of the following? Muslim law. Meher is the amount of the money or valuable security to be paid by the husband to wife as a mark in respect of her. Age of majority of matrimonial purpose under classic Muslim law is 15 years both for boy and girl. Children of a sister or a brother can validly marry under which one of the following laws? Muslim law. Which one of the following prepositions are correct? Both are correct. Muslim husband has right to have 2 wives. The first wife have right to withdraw from the conjugal society. Husband cannot claim restitution of conjugal right. A Shia Muslim husband email divorce letter containing triple talaq. Divorce will be void. Deferred meher is payable at a time of divorce or at a time of death of spouse. This statement is true under Sunni law. Under Muslim law, puberty is presumed at the age of 15 years. For a valid Muslim marriage, offer and acceptance must be at the same time and same place. If a Muslim marries with the 5th wife when he has already 4 wives living, the marriage is irregular. Mutta marriage is a concept in Muslim law. Minimum period of Mutta marriage is no fixed period. Muslim male A says in the presence of X and Y, I have married myself to B, who is not present. On receiving this information, B say, I have accepted. Which one of the following is correct? B is correct. This does not constitute a valid marriage, as offer and acceptance must be made at the same time in the same place. Muslim men cannot marry all of the above. Wife's mother, Sasuma, son's wife, Bahu, foster sister. Mark the incorrect statement. Shia male, female may contract valid marriage with Sunni female male. This one is right. In Shia law, at the time of marriage, the witnesses are not necessary. Right? 2 witnesses are mandatory in Sunni at the time of marriage. Right? Where consent to the marriage has not been obtained, consummation even against the will of women will validate the marriage. Wrong. This one is wrong. A Muslim male during lifetime of his wife W, with whom the marriage is subsisting, married to a younger sister to his wife. The marriage is irregular in Sunni law and void in Shia law. Conversion of Muslim wife to a faith other than Islam shall not be itself operate dissolution of her Muslim marriage. A born Muslim girl brought up in the Hindu family married a Hindu boy as per Shastric ceremony. The marriage is invalid. The marriage of Muslim male to sister of his present wife is void under Shia law and irregular under Sunni law. So marry Rani according to Hindu rites in 1980. In 1985, So marry Sonal according to Muslim law. After both became converted to Islam, Tom is being persecuted for bigamy. His defense is that he is a Muslim and his personal law permit polygamy. Decide. Som will be guilty of bigamy.